Hello, I'm Andrew Chapman and I'm the UKIP candidate for East Devon for the May 2015 elections. Hopefully, none of us end up in court. But there are some of us who do. And when we do in Britain, there are a number of protections that have been built up over centuries as a result of a lot of hard work and a lot of sacrifice by citizens in this country, some of whom have been put to death as innocent people, and their generations coming afterwards have wanted the situation to be put right and have fought and fought and fought for a particular change in the law that has enabled a number of protections of the individual against abuse by the state, against miscarriage of justice, that we prize in this country, that have brought us freedoms to get on with our lives. But sadly, those protections are beginning to disappear. As I say, most people probably don't have to go to court, but those that do are finding to their discomfort and to their cost, not necessarily their financial cost, but in terms of their freedom to get on with their lives, they're finding that those freedoms and those protections don't exist any longer. I want to try to explain the differences between the British system of law that has been built up over 1,000 years and the European system of law, which has its place, but not in Britain. It's a very different system of law and is founded on very different principles. They're not wrong, but they are different from those of the United Kingdom. And the two systems are fundamentally incompatible. Let's look at the British system of law, the common law that began to evolve when Henry II, who became king in 1154, instituted the position of Lord Chancellor, by which anyone in Britain could take his case to the king. And the Lord Chancellor was deputed to hear the case and to decide what the right judgment was. And what the Lord Chancellor decided began to be written down and formed our common law. In other words, if the same crime was committed and the same set of circumstances applied, the same judgment would be used. And over the course of those centuries since, our judges now have a considerable volume of judgments which they can draw upon to make sure that we have a consistent and totally impartial system of justice. The legal processes have, of course, developed over those centuries. Perhaps the next thing that happened was Magna Carta in 1215, where a system of trial by jury was instituted, where you could be, if you were an Englishman, tried by 12 of your peers who live in your community and know the way it works, and decide whether, in the circumstances of the crime which you are accused of, and which they hear the circumstances of, guilty or innocent. In the 1700s, William Garrow defined in British law the principle that anybody in England is deemed to be innocent until they are proved guilty, and the evidence must be found to prove them guilty. When you are arrested by the police in Britain, you are required to be taken before a judge by the police, and the police have to say what the evidence is for why you've been arrested and what the charge is that you are being accused of. That's called habeas corpus. And that particular right was instituted in 1679, a long time ago, as a protection against abuse by the political authorities of the individual. The protection of abuse of the individual by the state is at the heart of the British legal system. If you are tried in a court of law in Britain and you are acquitted, you are deemed innocent, you may not be charged with that offence again and hauled up before the court. The harrowing experience of being tried again. Those three protections of abuse by the state do not exist in Europe. The European system is founded on a totally different principle. It's called inquisitorial system, and as its name suggests, it's founded on the Spanish Inquisition's way of doing things, where the political authorities would haul you up before the courts and say, we are going to quiz you until you have satisfied us that you are innocent of what we think you may have done. And they don't even need to tell you what the charge is. You are deemed guilty until proven innocent. That is the European way of doing things. It was developed by Napoleon. European law, the basis of it is called Napoleonic law. You're deemed guilty till you prove yourself innocent. If you think about it for a moment, it is very difficult to prove yourself innocent when you know absolutely nothing about the crime that you are accused of. Just think about it for a moment. How do you prove yourself innocent of a crime that you know nothing about? If you haven't got a suitable alibi, you can't do it. And there are many people in Britain who have languished in foreign jails under a European arrest warrant who should never have been put there in the first place. And this brings us to one more fundamental strand of difference. In Britain, there is the legislature, Parliament, which defines what the law is. And there is the judiciary, which implements it, the police and the courts. And there is a fundamental separation so that there is no danger in Britain, in principle, of any political interference with justice. In Europe, the village magistrate is a political appointment, and the village magistrate can throw anybody he wishes in prison and not have to justify the reason for doing so. He doesn't have to produce any evidence. He doesn't have to tell the accused what they are accused of. Habeas corpus that we have in this country does not exist in Europe. Trial by jury does not exist in Europe. Political interference. The system doesn't protect the individual. Our two systems of law, British law and European law, are fundamentally in conflict. And a number of people in Britain now are finding that they are no longer protected from abuse by the state in the way that has been built up over centuries, with much blood shed and much sacrifice, and indeed much bloodshed to protect them, not least by people like Francis Drake against Philip II and the Spanish Armada, by the forces of Wellington against Napoleon, by the old contemptibles against the Kaiser's army, and by our British forces against Hitler in the Second World War. If we hand over the protections against abuse by the state, which this country has developed over 1,000 years, we are betraying all of the people who gave their lives to build up the freedoms that we enjoy in this country. Winston Churchill knew that. General de Gaulle knew that British culture, European culture were fundamentally at odds with each other, and Britain would not fit. But when they died, that kind of understanding died with them. And our leaders betrayed this country into becoming a part of a system which can produce nothing but conflict. Our freedom eroded and handed over to the Brussels model for 40 years, drip by drip, grain of sand by grain of sand, so that the bucket is now quite full. And the decision you're being asked to make on the 7th of May is, do you want to be subject to British law or European Napoleonic law? Do you want to be ruled by Westminster or Brussels under Berlin? It's your choice.